Morning, everyone. It's a real privilege to be part of this webinar and especially on the same panel as Anna Luzon. My disability is psychosocial disability, so possibly you will forgive me if my 15 minutes will be a less coherent presentation of a subject. I have been thinking about what core message, or at most 3 core points of message I should deliver in such a presentation. And then I started thinking about whether it's accidental that Access to Justice as a dedicated article is right after the legal capacity article, or it is a more built-in logic behind that. And before losing my point, I am telling you the answer I have. It is not accidental. You can look at access to justice through various glasses from various perspectives. One possible perspective is that basically access to justice is nothing else than your legal capacity in the field of criminal and maybe other justice systems. So then the question is, what is needed and what is not needed, if you like, what is counter-warranted in the process, in the establishment of justice. As Bruno said, my focus will be more on defendants than on victims, partly because I have some limited personal experience on that side, and partly because I do think that while I am not able to give a correct definition of what justice is, certainly justice should be something which is not only about the victim. It should not be only about the defendant. It should be about a situation, about an event, about harm, about consequences. And at this point, I should also share my conviction that Article 13 of the CRPD, in conjunction with all the other articles Anna mentioned, will not be and cannot be implemented properly without shifting the justice system's focus towards restorative justice and restorative techniques in justice. When can we say that a justice system is accessible for persons with disabilities, in particular persons with psychosocial disability, intellectual disability, and autism? Evidently, all the conventional accessibility measures should play an important role. Now we know that accessibility should be realized progressively. That means that accessibility, full accessibility, effective accessibility obviously requires resources. not only financial resources, but human resources. It requires shifting the minds of the participants, including the professionals who participate in the justice system. And it does take time. Now, we know that in situations when accessibility is not yet there, what the claimant still may, and as an advocate, I really encourage them that they should, refer to is reasonable accommodation. Let me share a story with you. When I came back from New York, from the session of the ad hoc committee, which adopted the CRPD, and I started talking to my Hungarian peers, many of them told me, Gábor, this is a real disaster. This reasonable accommodation idea is a disaster. And I felt really shocked because I, as one of the many thousand architects of the convention, was very proud that CRPD makes it clear that reasonable accommodation is an immediate obligation of the state parties. So what is wrong with it in the eyes of my peers? And of course it was about the word reasonable. And then come all the questions and dilemmas, who decides what is reasonable, where is the burden of proof, etc., etc. I would like to draw your attention to the text of Article 13, which otherwise I very seldom do. I am not a really textual human rights expert. But in this case, I think it's very telling. It talks about accommodations without the qualifier reasonable. When I was still in the committee, especially when we were working on General Comment number 1 on legal capacity, we had to think about whether this was an accidental thing that in Article 13, the language is not about reasonable accommodation, but accommodation in general. And our conclusion was that it was not accidental. What do I mean on that? Now, I can tell you only a few central issues here. Anything which may be necessary for either the victim or the defendant or witnesses, actually, to make sure that the proceedings will be non-discriminatory, will be de facto equal to similar proceedings with non-disabled actors, should be provided. There is no space to make delicate judgments on whether an accommodation is reasonable in the ordinary sense. Of course, irrational accommodations shall not be provided, that's clear. But anything different than that, which can be arguably necessary for more than what I could call a reasonable justice, which is a nonsense, should be provided. Now, Anna Lawson mentioned a very important aspect of reasonable accommodation, namely that reasonable accommodation is not a one time event. It's a dialogue. It should be an ongoing dialogue. Now, what about the accommodations required under Article 13? I do think, it's my personal opinion, though, that the same applies here. It should be an ongoing discourse, dialogue, which should also have, or at least could have, an impact on the justice system for all. I would really claim that CRPD, with its approach and normative framework and obligations on the states, is not only of and for persons with disabilities. It is really about the humanization of the justice system and making the justice system accessible for all persons. Justice system and its symbols are scary. I remember that the first time I went into a court building, I was the elected representative of an NGO, and I had to go to the court to register that NGO. And still, my heartbeat was above 100. I felt very unsecure because in my culture, in my country, in my historical context, courts were not really about justice. It was about power. And for many people, I think in many jurisdictions, it is the same until now. So if a person who is in a disadvantaged situation has to enter the court, physically or virtually, it doesn't matter too much, and faces all the symbols of power, it is disabling. So I would say that when anyone thinking and planning about access to justice for persons with disabilities should really start with thinking about the focusing the power. The power should be on justice. And when those who developed our current justice systems decided that the power of the court should be emphasized through symbols also, they did not mean that the power of the judge or the power of the judiciary. They meant that the power of state to facilitate justice. Thank you.